So I really didn't want to go first, but I have a question for Ms. Sandra. So, first of all, I'll give you a little bit of my thinking. I think the hearing officer did a very thoughtful and thorough job as he went through this, as you said. But one of the areas where I think, in fact, maybe the only area I think where there was a real question was on his decision, page 15.
Can I get that in front of you?
Sure, I just going to read it to you, so it won't be too difficult. It's page 15, it'd be packet page 1159. So there he's talking about the one bedroom and the unpermitted other mobile home bedrooms. And what he said here was, because the appraiser assumed that all improvements, including added bedrooms, had been legally permitted, the residents were able to receive a financial benefit from those improvements. In my judgment, it would not be reasonable to additionally require the owner to pay a rental subsidy for replacement housing in the form of apartments with more than one bedroom because of substandard bedrooms that were added to their mobile homes without permits. So what he's basically saying is that it's in his judgment that even though these people actually have two bedrooms, for instance, and there may be four people in a family, that you're only going to provide a subsidy for one bedroom apartment. And he hasn't grounded that in the statute, unlike he's grounded everything else as far as I can tell. When I go through what he does here, is basically, he looks at the statute and he makes decisions. This is the one case in his opinion where he says, in my opinion, which tells me that you could go either way on this and it's a discretionary issue. And then I come up further in my head and tell myself, well, why should that be so? So I wanted to give you an opportunity to say why they shouldn't have. There's four people in a family, for instance. You can't fit four people in one bedroom. I don't remember what the maximum amount in one bedroom is.
It's usually two, the HUD standards are 2 + 1 per bedroom.
That's what I thought. So
it's three in one bedroom.
And the number of families that come forward and talk about that there's four or more in a family, they have these illegal or unpermitted bedrooms. So it seemed to me that the right thing to do would be to say, frankly, that the homeowner should provide, not the homeowner, the partner should provide that rental subsidy for the family based on a two-bedroom if there's more than four people. So I wanted your reaction to that, why that would not be appropriate, and given that the whole purpose here seems to be to move people from, this housing to new housing. And it seemed unrealistic to move to a one bedroom, frankly. So I wanted your reaction to that and why I'm incorrect in my thinking.
No, my reaction is this, is that I think what the hearing officer was doing is saying that the residents have already been given the benefit of living in a self-created, unpermitted 2-3 bedroom home because the appraiser has been instructed to ignore the fact that they are unpermitted. And so, for example, in the picture I showed you last night where someone enclosed his entire space and the tree and thereby created 3 bedrooms by literally creating walls around asphalt, okay, that they have already enjoyed or benefited. And first of all, they have that much living space. Secondly, the appraisal assumes a 3-bedroom home there and gives them that appraised value. So they capture the value that way, okay? And therefore, is it necessary then for them to capture it again in terms of a rent subsidy? And again, I remind you that the rent subsidy is market rate housing in Palo Alto and surrounding cities. The rent at Buena Vista does not represent market rate housing because it is rent controlled under your ordinance. And in fact, it's in the documents before you. If you didn't recognize it or if you don't remember it, there were many years, including the 2 years prior to this January of 2015, that the park owner never increased the space rent, which is why I continue to say this is the cheapest non-subsidized affordable housing in Palo Alto. I think we've all concluded that. But my point is, basically, I think Mr. Labadie was finding that you don't get, essentially, the benefit twice, okay? It's already captured in your mobile home, which is part of the lump sum assistance you will receive. And for families who do not want to rent or need to rent a 2 or 3 bedroom apartment, okay, again, if you look at the amounts of the mitigation assistance for rent subsidy, I think even for a 1 bedroom, it's $22,000. And so maybe they're not going to rent the highest end market rate 3 bedroom apartment in Palo Alto or a surrounding city. Maybe because they can't either, the other problem of course is they may not income qualify for that anyways, but in any event, even with that money, that may be their choice because that money is for a 1 bedroom apartment and they may require 2 or 3 bedrooms. But the ordinance does not require us to pay that rent subsidy.
So the ordinance may or may not. So my question to you is, say as a council we were to impose that as an additional condition. That would be that if there are 4 people that you provide at least rent subsidy for a 2 bedroom. Do you see any legal impediments to us as a council imposing that under a condition or anything in the record that would prohibit us from doing so?
Well, I think, for example, there are, I believe, that there are multiple families living together in the same homes here. And the fact that so under the 2 + 1 per bedroom rule, if you had a family of 6, that is a 3 bedroom home. If you have a family of 7, that's still a 3 bedroom home. If you have a family of 8, then you're in a 4 bedroom home, okay? I think the rent subsidy far exceeds the reasonable cost of relocation. A 4 bedroom apartment, first of all, I don't even know that those exist.
So I think I limited it to a 2 bedroom.
Okay.
I said a 2 bedroom apartment if you have 4 people or more living in a mobile home. I actually said a family group.
Okay, all right, so
Because I agree with
you're
you, 4
suggesting,
bedroom would be-
okay,
I'm suggesting you basically go from 1 bedroom, which seems to be everyone except for a few, and then to a 2 bedroom if there's 4 people. That's really what I'm suggesting, you provide that rent subsidy. And I'm asking if there's, any legal impediments or anything in the record or any reason why I shouldn't do that. Because I'm really concerned that, frankly, that 4 people won't be able to move to 1 bedroom. And that's my big concern.
I think the only impediment is that it was not the decision of the hearing officer, and we have affirmed that, we have accepted that decision. So I think that gives us grounds to, certainly it would give us grounds to appeal this.
So would it, is our standard as a no-vote review that has to be grounded in the statute, obviously, or really no-vote review don't do the hearing officers?
Yes,
It's
I
not
would,
understand.
you can ask that of your city attorney, yes, but still, that doesn't take away our right to appeal to, under a writ of mandamus, to a superior court.
I was just really asking you what those grounds could be.
What is the grounds for the appeal?
Right.
Oh, I think because they either, and I have to look at the statute again, either they exceed the terms of the ordinance or they exceed the reasonable cost of relocation. Because I think that the residents have already benefited from those illegal additions in the form of the appraisal, and he recognized that fact.
All right. I actually have a question for the residents' council. And I'll be just as difficult with you, I promise. So, could you explain to me your understanding of the 35-mile radius?
So our expert witness, Libby Seifel, she actually drew a radius of a 35.
Well, why did she draw a radius? I mean, why are you looking at 35 miles and how does that relate to the statute?
Oh, so, good question. I mean, the statute specifically refers to, specifically defines comparable housing, and I have it in front of me. I'm sorry, so in looking at, give me a second.
Take your time, don't feel rushed.
Okay, so, the ordinance specifically requires, that residents whose mobile homes can be relocated, the cost of physically relocating the mobile home as defined above within 35 miles of the park. There's also another part of the ordinance where the owner has to look, when the owner is required to do a relocation impact report and look at where comparable mobile homes parks are, that is limited to 35 miles of the park. So the ordinance really contemplates a comparable community within 35 miles of the park.
So let me just
we're
stop.
looking at the greater Bay Area.
Let me just stop you there. When I look at the ordinance seems to be broken into two parts. And correct me if I'm wrong. The first part is for residents whose mobile homes can be relocated to a space in comparable park. And the second part is for residents whose mobile homes cannot be relocated to a space in comparable park. Now, what I've heard in the record, what I've read, and correct me if I'm wrong, is that there are no park spaces, maybe there was a few, but I thought there was virtually none that are actually going to be relocated. If there are some that are going to be relocated, tell me, but my recollection is that there were none. That everyone's taking the lump sum payment or getting comparable housing.
And there may be a few residents, but the vast majority of residents are not going to be able to move their mobile homes.
And it seemed that the 35-mile radius, when you look at the statute, is very clear. And if you disagree, tell me, because it seems crystal clear that it only applies to moving your mobile homes from Part A to Part B in that 35-mile radius. That when you look at, on packet page 8, it's 7 of the page of the ordinance there, under number 2, it makes it really clear there's nothing about 35 miles. And when you read the stuff about comparable housing in the definition section, there's nothing about comparable housing. So I almost feel like you've misled the council a little bit on this, on the 35-mile stuff, because I don't see it in here at all. And I'm a little troubled by that. So I wanted to give you an opportunity to address it so I don't hold it against you.
Okay, so, the lens that you really have to look at is looking at what's going to mitigate the negative aspects of the park closure. And you've heard residents talk about the reason they live here is to be in Palo Alto and to access the community amenities that Palo Alto has. And we look at what comparable housing is defined as. It has an inclusive list of amenities which requires similar access to public transportation, to job opportunities, to medical facilities. So we're really looking at a comparable community to Palo Alto. And so,
So let me just ask you, where in the statute does it say comparable with Palo Alto?
it says, look at the definition of comparable housing. It means, so if you look at what the RIR requires, this is,
So where are you looking when you say when the RI requires?
this is 9.76.030, and that's J. It's talking about a list of comparable parks within a 35-mile radius.
Right, page 5, okay.
Right, and so,
But isn't the reason for that list of comparable parks, and I want to belabor the point, because the idea is that part of the statute in verse says that you're going to move your mobile home parks, it should be to a park within 35 miles. And that's what the comparable, and then you get a separate set of benefits, frankly. You don't get the same benefits. Whereas under part 2, which is part I, there's no 35-mile radius, and it's a different set of benefits.
right, but that part of the ordinance also talks about comparable housing and defines comparable housing as I quote, the cost of purchasing a comparable mobile home in a comparable mobile home park. And even though the definitions of comparable mobile home park do not exactly use the term 35 miles, it's looking at a park with access to a similar community to Palo Alto and similar amenities. And also, if you look at the ordinance as a whole, it's looking at parks within the 35 miles. And so, when this ordinance was enacted, the purpose of it was to allow residents to stay in a similar community to Palo Alto, be able to keep their dogs. With the understanding that this was the last mobile home park in Palo Alto. So, the intention of the ordinance was to look at comparable housing within a limited area. I mean, the ordinance was not intended.
So where do you find that in the record? I found that nowhere. In fact, I found comments by council members saying the park probably has a 10-year life, that we should do a development agreement and come up with, a development plan. I actually have got to say that I didn't see that in the record. I mean, I wish it was otherwise. I'm actually very sympathetic to your position, but that's not what I saw in the record. So where in the record would you direct me so I can base my decision on the record and come up with that?
So, again, if you look at what the definition of comparable mobile home park, and comparable community is, it specifically says a community that has similar access to shopping, medical services, recreational facilities, and transportation, or a comparable mobile home and a comparable mobile home park. And in other places in the ordinance, when they're talking about comparable mobile home parks, they're limiting it to 35 miles. I mean, the purpose of the ordinance is not so that all of these residents are forced to move to the Central Valley or Wisconsin or wherever they can afford to, but it's to be able to keep them in a similar community to Palo Alto. I understand it's not the clearest ordinance in the world, but you have to read it in light of what it's going to take to mitigate the negative aspects of the park's closure. And reading it that way would really force residents to lose their jobs. It would force residents to move away from their schools. It would require residents to move away from where they get medical services. And that's really not the intention of the ordinance.
So you asked for an answer, and this is probably the last question I asked you. You said, what would you have us do as a council? Maybe you could elucidate a little bit on that. When you read the ordinance, it talks about, this is what it actually says. It says, the hearing officer, and that's under it's under page 6, under G. The hearing officer shall approve the application on condition that the mitigation measures proposed by the park owner are adequate to mitigate the adverse impacts on displaced residents and may condition the approval on additional conditions, including but not limited to the following. And then it talks about for residents whose mobile homes can be relocated, and that's where we disagree on the 35 miles. That's the only place it talks about it. And then its rest of the structure of the ordinance is for residents whose mobile homes cannot be relocated in space of a comparable park. It lists a bunch of items. And so I guess what I'm asking you is within that structure of the ordinance, because that's sort of what we have to deal with, what could we do to support the residents of Buena Vista if you were going to ask us to do something? And I don't think it's really that helpful to just say, don't close the park. That doesn't seem to be something that the ordinance anticipates.
So the park owners talk about how there's no plan, but the ordinance does contemplate a plan. It does contemplate allowing for enough relocation assistance so residents can move to a comparable mobile home in a comparable mobile home park. And the ordinance specifically requires them to look at mobile home parks within 35 miles. Requiring that information is not so that there's just information or a list of information in a vacuum. It's so that there can be a plan and there can be places for residents to move to, an analysis of what residents will need in terms of the relocation assistance to be able to move to those communities. And the park owner hasn't done that. They've mentioned some HCD listings. But if those are really realistic options, the park owner has to identify them, has to tell us what the mitigation assistance will be to allow residents to move to that. All we have right now is an updated appraisal. We don't know what the amount is. We have an estimate. It could be less, lower, it could be more. And there's no way for residents to appeal that if they're not going to be able to find comparable housing in a comparable community. That's for us what's most problematic here.
Well, thank you very much for bearing with me.
You're welcome. Thank you.
Vice Mayor Schmidt.
Just a simple economic question. I know the Palo Alto code says that for each space in the park, it is necessary to measure the value of the mobile home to have if the park cannot be closed. Now, we've had a lot of data presented and people making cases, but I was disturbed a little bit in Mr. Beccaria's presentation tonight. That he made the statement that there's been one sale financed in the last 20 years. Another statement, only 2 sales were recorded by the major listing plan, HCD based. Another statement, it was hard to get data from any other source about sales, even from the residents themselves. So it seems one of the issues or problems in assessing value has been the difficulty of getting sales data from the Buena Vista Park. This is a historical issue. Yet in other parts of the report, they listed that between 2011 and 2013, there were 27 listed sales at the Sahara Village, which they used for comparisons, and 45 listed sales at Santiago Villa. Now, this just as a simple comment, I look at that and find that extraordinary and astounding. What it seems to say is that people living at Buena Vista don't want to move. And that would mean longevity is one of the characteristics of the park. And longevity for the community has value. So I guess the question I would have for the owner's attorney, or Mr. Beccaria, is how do you assess the value of people wanting to stay, not wanting to leave? Attorney Nanda, you mentioned in your introduction that you've been involved in 10 closures, 6 of which have closed. Is it extraordinary in your experience to see a mobile home park that people don't leave or longevity is as high?
So can I clarify just a few things in your prior statement, and then I'll get to the last question. So I think, first of all, you may have misunderstood what Mr. Beccaria was saying. He was saying that he had seen only one MLS, multiple listing service, listing of a home at Buena Vista for the past several years. The homes at Buena Vista, given what they are, with unpermitted additions, and because this, as I keep saying, is not a traditional mobile home park with landscape spaces and wider streets and uniform type houses, etc. It does not look like Santiago Villa or Sahara or those kinds of parks that you've just mentioned. People do not list the homes for sale on a multiple listing service. If you recall the testimony last night from several residents, there were many who said they had moved in 2000. There were some who said they had moved in the 90s, but there were many who said I moved in 2006 or moved in 2008, and so on and so forth. The typical way that I believe, and in my experience, again, as doing this kind of work, is that sales are, in this kind of mobile home park, are almost word of mouth or by someone literally putting a for sale sign in the window. And as people walk in or drive through the park, typically that's how people find mobile homes for sale anyways. They drive through parks on the weekends and see for sale signs, whether they be by owner or by a listing service. And I think the other thing that is maybe confusing here, which I want to see if I can just clarify, is that for a mobile home, the state of California, Department of Housing and Community Development, requires that the home be titled or registered with the state of California Department of Housing and Community Development. So of the 30 mobile homes that are in this park, they would be titled by HCD, and they would be on the personal property tax rolls of Santa Clara County. As to the other types of recreational vehicles, travel trailers, and the other 68 homes, those are registered most likely through the Department of Motor Vehicles because they are in fact a type of vehicle. Now, what Mr. Beccaria was saying was there is a private data service which both he and I subscribe to, and we have no reason, we do different types of work, called Santiago Financial, and what they do is they send somebody to the HCD office because every mobile home sale has to be registered, and it is broken down by park and city and county, so that you could see what mobile homes have sold, and that's what I was referring to last night. And Mr. Beccaria was saying that that data is often delayed. It's a private service that does it. So sometimes they pick it up right away and sometimes they don't. In his case, in order to verify he had the latest information, he called and discussed with them anything he may have been missing. For DMV, you may or may not be aware that you or I cannot walk up to a counter and say who owns that car. They will not tell you that. However, there is a process if you have a VIN number or other identifying number and you are an attorney where you can apply on a form to DMV to find out the ownership of a home. So I don't know if that clarifies what you heard, but that is in fact the reality. Many of these are registered through DMV, some are registered through agencies.
Yeah, thank you very much. I guess the direct question was, did you find a difference in longevity in this park compared to the 6 others you had worked in?
So first of all, this is an all-age park, and I will tell you there is a huge amount of difference in my experience in terms of longevity in a senior park. In a senior park, mostly the qualification is that one person per household be age 55 or older. That is under the HUD requirements. In my experience, there are people who are living well into their late 80s and early 90s who bought the homes in mobile home parks, who, because of the dimensions of a mobile home and whatever, they can manage, and so they live autonomously or independently. And so in my experience, the people who are most determined to hold on to their homes and do not necessarily want a park to close are the people in a senior community. And I have seen that much more so than in family communities.
Yeah. Any response from the residents?
Thank you for the opportunity to respond. First, many residents have lived here for 20 plus years. I believe one of our expert reports has that information, but if I can get specific information, I will get it to you. Jim Brabrandt's report that we provided to you also has some critiques about not only about longevity, but about the sales and comparable sales data that was used, particularly there was a critique about how it was hard to get data sources, but Mr. Brabant found that it wasn't as difficult. Some of that critique is in his report. The park owners expert also said that permitting is ignored by market participants, but most of the residents actually did buy their homes with the additions already in there, meaning that they paid more for their additional space because it included the additions that the market supposedly ignores. And the idea that they're getting a windfall because the appraisal assumes that the assumes that the additions were permitted is incorrect.
Thank you, Councilor Ernest.
So if I could start with Ms. Nanda.
Thanks.
And really what I'm looking for here is an explanation if you happen to have one. So far tonight, we haven't addressed the school issue. And looking on page, this is the packet page 214, and it talks about other mobile home conversion ordinances having mentioned schools, but in ours it's conspicuously absent. So have you dealt with this in other cities who clearly had a great deal of experience with this? Even though it sounds as though a lot of your mobile home parks probably have people who are older, is that correct?
I mean, I have closed both family parks and cedar
And
parks.
others.
Yes.
So if you would comment on that, and I realize you can't know why in 2001 the schools were left out, but it would be helpful to know any of your either experiences or observations about the schools and how they were included in those closures.
Well, I have to say that I have, in the 6 closures that I have completed, there has not been a similar issue presented with respect to valuing the schools as they are suggested to be valued here. What we tried to present at the hearing and in our closing brief, and we have included in the council's packet, is the record of the council meetings of this council, in which, again, the Assistant City Ariel Colon indicates that he has reviewed a number of ordinances. He specifically mentions Monrovia. Monrovia's, I have it with me, it does include the word schools, it's similarly phrased. I cannot speculate why it was left out. However, I respect Mr. Lavity's conclusion that it does appear as if the legislative intent to include schools was not there, because they are, again, the residents were represented by council, and again, one of the residents indeed testified last night, she remembers schools being discussed at the resident meetings with the council members and staff, which of course my client did not attend, but indeed he was not solicited. So to get back to your original issue, I have never had in the other 6 closures the issue of schools being raised as a barrier to finding another mobile home or other type of housing. This issue has surfaced in this case. I don't live in Palo Alto. I have lived in the Bay Area for 35 years. I have always heard about the fabulous quality of Palo Alto public schools, so I'm not here to dispute that. I only know what's in the ordinance.
Yeah, I appreciate that, because I think it is somewhat puzzling.
I think it's very puzzling.
Because we, even though they're all still alive, to be quite honest, from 2001, I haven't gone back and asked anyone. I think it's difficult to recall why you might have done something almost 15 years ago.
Well, and the fact of the matter is, as we pointed out, it's my understanding, and I remember the public testimony, which is on record, at the 3 public hearings. And there were a number of older residents, well, I shouldn't say older, I'm not young myself, but there were people who said that they had purchased homes in Palo Alto in 1963, in 1970, that they had lived in the community many years, and they moved here originally because of the schools. So my belief is, or my understanding was, although I do not and did not live in Palo Alto in 2000 and 2001, that the schools were good even then. So I would have assumed that had it been a critical factor, it would have been included, and it for some reason was not. I will say, we attempted, my office attempted to contact Ariel Colon on a number of occasions, and I will not recite all the ways in which we attempted, and he did not wish to speak to us. Now, whether he spoke to anyone else, I have no idea, but he would not speak to us about the matter. And I think that's all I can say.
Good, thank you so much. And if the residents want to speak to it, it's fine, but I really needed a clarification from Ms. Manda as to the actual ordinance and whether or not she had had experience with that before. If you wish to speak, fine. If not, it's it's perfectly okay.
You've heard about the importance of the schools, but, I mean, besides that, I just want to also mention that the term, both comparable mobile home park, comparable housing, looks at a community that's similar to Palo Alto. It says similar access, a community that's similar to that in which the park is being closed is located and has similar access to community amenities. So even if we take schools out of the equation, it contemplates a community similar to Palo Alto. So I just want to make sure that we keep that in mind as we're looking at this.
Thank you. Councilmember Berman.
So, one quick question for the park owner's attorney. Were the residents, whenever they built additions, either permanent or unpermitted, were the rents on their spaces altered at all?
No,
Okay.
they were never increased because of the additions.
Okay. And a question that I have, thank you. A couple questions that I have for Mr. Baccaria, and I might be pronouncing his name correctly.
Yes.
So, I just want to confirm a couple of facts about the appraisals that you did. How many Buena Vista sales do you use in your comparisons?
It varied with each report. There was at least one in every report, sometimes two.
On the whole, though, I mean, in
How
the
many
totality of the
total?
appraisals, yeah.
Probably 5 of them altogether, something like that.
And were those sales that had occurred within the 12 months before your appraisal, or did they go back further than that?
I think the most recent one was in late 2011.
Okay,
Yeah.
so a
Oh,
little,
wait, no, there was a couple of the trailers that sold in 2012 that were used.
but some of them were further than 12 months.
We had to use for the park model units, the last sale in the park of the park model unit, which is licensed under the Department of Motor Vehicles, was in 2006 when it was put in the park new.
Okay.
So we had to use a piece of data to replicate that issue. So we put that in the report on that particular unit.
And then you'd mentioned a couple of times Mr. Brabant had alluded to home sales in other mobile home communities in the area that had occurred more than 12 months prior to the appraisal. And let me know if I'm misunderstanding your response, but you seem to dismiss those as saying those that occurred prior to, greater than 12 months before your appraisal, and therefore, due to professional standards, it wouldn't make sense for you to.
Well, you have to follow the trail as closely as you can, and time is a critical factor. And some of the sales that he was citing dated back to 2010. I can go in similar parks or even the same parks and find a sale in 2011 or 2012. I've got to go with the latter ones. I can't go back until I can get a one that is, you can't do that.
Sure,
You have to
sure,
pick the ones
yeah.
that are the most similar and most recent.
Now, let's say, and I mean, I don't understand your profession at all, and so I'm trying to get clarity on it here, but, so if there were, let's say if there, in the year before, had been 2 sales that were kind of wildly different in terms of the valuation of the mobile homes, would you then go back further to try to figure out what the norm is versus what was an outlier?
We were bouncing between the parks, and we had a group of parks, maybe about 8 or 9 of them, that we were, rather than going back in one park to find data that's dated, we would go to another park where the data was more current.
Okay.
Yeah.
And then, so the issue of time adjustments came up, and I was able to understand a lot of your report, which I thought was quite well written and persuasive in your reply, but I didn't quite understand why you dismissed the concerns about time adjustment using a $20 per square foot flat rate across all the different properties.
Well, the time adjustment issue is an interesting issue. At the time, when we were dealing with the 2011 sales that we included in the report, when we did the analysis, those all showed up on the higher end of the value range. And with our 2012 sales, we're showing up a little bit lower. And so if you're analyzing all the data, and it's conflicting with what the statistical data says. You've got to go with what the primary data says. It overrides, it trumps the other data. So we didn't make time adjustments between 2011 and 2000, I think January of 2013, late 2011. Now, with regard to the, my brain freeze here, you had another issue that
It was using the $20, I mean.
the $20 per square foot
Yep.
for the adjustment. Basically, you're dealing with substandard housing, and most of the values are, I think the average value is around 18 or 19,000 or something like that. And that's the minimum adjustment. I mean, there is no higher adjustment that's warranted. When you start running the numbers, it skews all of the analysis.
Okay.
It just throws it all out of whack. So you end up kind of going, well, maybe you wanted to explore that, but when you started to do it, it did not work when you analyzed all of the data simultaneously in your reports.
Okay.
You got to follow that trail. That's the primary trail. You can't deviate from that.
Okay, thank you. One last question. I'm trying to remember where it was. Actually, again, in the time adjustment criticism, you actually alluded to the fact that the median sale price in 2012 for mobile home parks in Santa Clara County was $70,000, but in 2006 the price was approximately $85,000, which is why it would have been a negative adjustment. You chose not to do it. The question that I have is, rather than using Santa Clara County as the geographic region comparison, would it make more sense to you? I mean, Palo Alto, we're right on the border of San Mateo County. We have more in common with Menlo Park than we do with Gilroy. With those communities, is that the right comparison you make?
Yeah, I needed mobile home park data. I need a lot of it. I need a lot of good mobile home park data. Not there in Menlo Park.
Oh, really?
Yeah.
Or Redwood City, or
Yeah, Redwood City has some parks, and there's some parks that are sort of in competition with this, but they are quite a bit. I mean, the locations are not the same. I'd rather go to a mainstream mobile home park for the data, because the data in those other parks, it gets below 8,000, 5,000, 3,000. I mean, I didn't want to do that because I didn't think that was justified comparing those locations to
Gotcha.
Palo Alto. I mean, I'd rather go to Sunnyvale or Mountain View where I've got
quantity.
I got quantity of data, and I've got good data, and I've got something where park efficiencies are offsetting the location issue.
Understood.
And it made more sense, and it resulted in a credible report. Some of the other areas that the data was so bad that it was just not worth chasing.
Gotcha.
It would have brought values down.
Okay, thank you very much.
Okay.
Then just a question for the prior questioner. Do you have anything that you want to ask the other attorneys to respond to in that or not? It's your call.
Yeah, please, if you'd like the opportunity to respond to any of that, you're more than welcome to. Or if you have any kind of comments or thoughts that you want to make.
And just generally, a lot of our criticisms are in Jim Braban's report, and if the council has questions specifically for him, we can ask him to respond in writing if you feel that's appropriate.
Thank you.
Thank you, Councilmember Du Bois.
First of all, thank you, Councilmember Sharp. You asked the questions I wanted to ask about units, the number of bedrooms and people, and why it was different for appraisal versus rent. I think it's the owner's attorney. There's a chart in our staff report which is pulled from the tentative decision about the rents. If I could ask you a question about that.
So it's in the, Mr. Lavity's tentative decision?
It is, and it's observed in our staff report. It shows the average rents for 1 and 2 bedrooms. Do you know that table? It's page 10 of our staff report. From yesterday. It's at the end of your letter. I don't know if it's part of your letter.
Okay, of my statement that I submitted?
Yes.
Okay, yes, okay.
Looks like this.
Oh, that chart. Oh, okay, so that was our attachment. Okay, one sec, exhibit A. Yes, it's our exhibit A. Oh, sorry. Sorry, sorry. For some reason, I'm not. Okay. Do you have it, Molly, can I look at it? Sorry. Okay, all right, I have it. Exhibit A, yes.
Yes,
Okay,
sorry.
I'm sorry,
So
yes.
just questions about how this
Yes.
table was constructed.
Yes, okay, sorry.
How were the sources determined? Like, I haven't heard of rentbits.com or Rent Jungle. And then Zillow, they seem to have, different
So
prices.
we used these internet source in the preparation of the various versions of the RIR, the city attorney requested that we provide data on market rate apartments in cities surrounding Palo Alto. And so we used Sunnyvale, East Palo Alto, Mountain View, Redwood City, and of course Palo Alto. And so what Mr. Lavity's Exhibit A, what his decision says is that his Exhibit A says you are to take an average market rate one-bedroom apartment, and that the rent subsidy will be based on that average of Palo Alto and the surrounding cities. So for purposes of this chart, because of course, we have been criticized that we have not spelled out what the mitigation assistance would be. And again, the data in the RIR is old because it was originally approved in March, April of 2014. So we ran these figures again, and we had been using internet sources for average rents and in those cities. So we did that again.
So like rent bits, are those listing prices or actual rent prices?
Okay, my associate actually gathered that, and I'm going to let her answer that. This is Sonia.
Hi. So those are actual rent prices. If you look at, I couldn't just use Zillow. There's like real facts data which tracks larger complexes of 50 units or more. So those are going to be higher end luxury apartment complexes. If you look for rent data, you can look at Zillow, you can look at Rent Jungle, you can look at RentBits, and do it per city. And this gives you an average per bedroom unit, studio, one bedroom, or two bedroom. And we did this in the interest of comprehensiveness because we wanted the best average we could come up with, which would be using all those out there. And I personally, based on my own experience living within this area, the rents are higher than most of my friends would even pay. So, and they do live here currently in larger complexes as well. So I feel pretty comfortable that that's going to be an inflated average because the data that's easiest to track for those algorithms that there's a lot of rent startups try to track this data, they're using easy to find data, which is larger complexes.
And then how you said cities surrounding Palo Alto, but there's some cities missing. So, why wasn't Menlo Park, Los Altos, maybe Burlingame, why weren't those used?
The resident relocation impact report used these cities. So what we did was I went to the RIR and I used the same city data. And then we just refreshed the data to make it more current. So if you want to ask why other cities weren't included, you should ask Margaret.
So those were the cities that the city attorney, we would present data, and then the Residents Association would write a letter why it wasn't good data, et cetera. And then eventually, and so we were instructed by the city attorney who was reviewing the report and staff, there was the planning staff, et cetera, but the letters would come from Grant Calling, and we were told to focus on these cities, so we did that.
So did you propose the cities initially, or where did they come from initially?
No, I think that we originally, I'm sorry, it's hard for me to recall now. I think that we may have only tracked we may have only initially tracked Palo Alto data, and then he asked for surrounding cities, or, I'm sorry, I don't recall.
Okay.
No.
I mean, I did find it surprising that there was only a $300 a month difference between a one-bedroom and a two-bedroom.
Yeah, I mean, we're just taking the data, again, I don't know, I mean, we certainly, again, it was felt that these were, I guess it was felt that these were surrounding cities, also that, because again, there is an issue here of income qualification by these residents. You've now heard what their incomes are, as told to you by the Residents Association. This is reporting market rate housing, and they even articulated last night the 3-to-1 housing, income to housing cost ratio. So I think that the feeling was, as I recall it now at the time, that say Sunnyvale and Redwood City are probably more affordable than apartments in Menlo Park or Los Altos. And so that's why we did not go to that data.
Okay.
Because I think it was a question of these cities were surrounding but more affordable.
Thank you. I have a couple of questions for Mr. Becerra, Rebecca Rios. So it's a question about this idea of valuing the mobile homes in place as if the park were an ongoing concern. So wouldn't the expectation be that if the park were an ongoing concern, that some of the infrastructure would be repaired and upgraded? It seems like there was, because of the condition of the park, you factor that into the appraisal. I'm just trying to jive that idea.
Condition of the park. I was making the point that currently, with regard to the infrastructure, that currently you cannot replace an older home with a new home in there, with the exception of park model units. And they're not manufactured homes, so they cannot be financed.
I'm talking about the infrastructure of the park itself. It's my understanding is the sewer hookups and things are also substandard. Did that factor into the in-place values?
I did not entertain sewer hookups or anything like that.
Or amenities in the park or anything?
Amenities, yes. I mean, it doesn't have a pool, it doesn't have a nice clubhouse with all the facilities in it. There's no other major facilities. You have narrow streets. Those kind of issues were factored into it, yes, because they are inherent in why a location adjustment was made.
And then I don't know if you're the right person to ask, but maybe your expertise. So generally, who's responsible for making sure additions are permitted in a park?
I think that falls under the jurisdiction of the state of California Housing and Community Development.
Does the owner, though, have a responsibility to?
You're going to have to ask an attorney that. I don't know. But the inspecting agency would be ACD.
Okay, thank you.
All right.
Councilmember Phillips.
I have one more question, sorry.
Oh, I apologize. I thought you were through.
Question for the residents' attorney. So you've talked about different aspects of comparable community. We heard a lot last night about safety. Was safety specifically discussed as an aspect of comparable community?
So comparable community, it specifically says a community that's similar to the community the park is in with similar amenities and such as, and it lists amenities. It's not an exclusive list, so it can include other things. And it contemplates a safe community because it contemplates a community similar to Palo Alto. I mean, you've heard so many residents testify about one of the reasons they moved to Palo Alto is because, and moved to Buena Vista is because it's a safe, affordable community. So I do think that that should be factored in. And if you're looking at what constitutes a comparable community, it should be a safe community with similar access to similar amenities as Palo Alto has.
Okay, thank you very much.
You're welcome.
Now we'll go to Councilmember Phillips.
I wanted to ask something of Mr. Beccaria.
Yes.
I suspect you're going to get a lot of nerdy appraisal questions from non-experts here tonight, so I want to thank you very much for being here with me to do this. I have three questions. first is, I know you explained this earlier tonight, and it's in your written report, but I still don't completely understand how location factors into the appraisal result. And, you know, you said that the condition of the park and the pad sizes and the infrastructure and so forth, right, offset the location. But I don't quite understand that completely yet, why it's an exact offset, or one's a little more, one's a little less. So if you could explain that again, that would be very helpful. My second question is that one of the residents last night, I think it was Ms. Escalante, said that the appraisal value was actually less than she had paid for her unit. And I wanted some color on how that's possible. And then my third question has to do with sort of the definition of, and I think Councilmember Du Bois was going to allude to, of in-place value. And as I understand it, the in-place value is, you know, you assume the park would continue in perpetuity, and then that's how it happens. However, in this particular case, the park owner family has been clear, in fact I would say admirably clear, right, for many years about their intent relative to the disposition of the park, and it would not be going on forevermore. And so it seems to me that somebody who was contemplating moving to a park that they knew would be closed in a few years, right, it seems to me that that would actually depress the value of such a unit. And I wanted to ask, is that true, and is it encompassed in the appraisal? So sorry for the long three-part question.
I'm a kind of a plotter type of a guy. Can we do them one at a time? Can we ask the first question again? Otherwise, I'm not going to be able to do this.
Yeah, okay. Sorry about that. So my first question is, can you explain one more time how the location bears on the appraisal? And you said that the location, the advantages of the location are offset by the condition of the park and the pad sizes and the fact that homes can't be financed and so forth. And why, I don't understand why those offset each other one-to-one, and sort of what the thinking behind that is. And I know you've explained it, but I didn't get it.
Well, we're dealing with Palo Alto, as we've all been discussing. Dealing with Stanford, terrific school. I mean, the high school's terrific. All the schools are terrific. You've got all these families that want to be in Palo Alto. They want that connection. They want it for their kids. And all of that. It's a dream. So they're willing to accept all of these park deficiencies to achieve that. How I got to that conclusion was correlating the values in the park over time to what's going on in the surrounding communities in traditional mobile home parks. And they did correlate. It was the closest and most practical way to develop a value. In other words, people that are buying in Sunnyvale and traditional mobile home parks, Sahara Village, Plaza Del Rey, wherever, Joby Wells, all the rest of them, they're paying about what these people are stretching to pay over here for similar space. And when you think about it, you have to ask yourself, why in the world would they be doing that? Because these other parks are quite a bit better, and the only variable is Palo Alto. And that's what it boiled down to. It was the only way to attack the assignment problem. And basically, I drew an equal sign, plus or minus, between the locational issue and the park deficiencies, their buyer's acceptance of the park deficiencies. That's what's going on, and that's how I see the market. And we studied it till we were blue in the face, looking at it from every possible different angle.
And so, if I understand what you're saying, you ran a regression on all kinds of other factors, and the difference you attributed to the location. Is that basically it?
The park deficiencies and the locational issues were crossing each other off. And also part of that was space rent differences too. Some of the parks had much higher space rent, not all of them, but some of them. But then when you think about the space rent that they're paying relative, even under rent control, to what the size of those spaces were, at least they're tiny pads. All those those issues combined, and the fact that the prices were relatively similar, that had to be the difference. And it makes sense. To me, it makes sense. I realize it's quite a complex problem, but like Mr. Schmidt, it's an economic issue. I mean, the economics is I gotta be in Palo Alto at all costs. And I'm willing to do this to get my kid into Stanford, or to get my kid into the high school, or to get my kid into that school district. I'm gonna make every possible sacrifice to make that happen. That's what's going on. Who can blame them?
Okay, thank you. So my second question was, one of the residents last night commented that the appraisal value on her property was less than she had paid for it. Is that possible?
Yeah, it is possible. Trying to address, we did over 100 appraisals, and I don't have any files here. I really am not in a position to address an particular appraisal. What the comps were, what we concluded at, what the analysis was, all the rest of it. It's beyond what I can remember. I just can't recall that much detail. It's 2 years ago, too.
It is the appraising. So my last question was, the fact that the park is known to be intending to be closed in the near term, it seems like that would have an impact on the value of the properties inside. Is that correct? And is that captured in the appraisal?
We were very, very careful about that issue. Right at the outset, I asked all those questions. Has the park closure been announced? Are the residents aware of it? If so, what was the date that happened? Only data prior to that date could be utilized. If there's knowledge about a park closure, all that data afterward is tainted. And you're right, it cannot be used. But we only use data that we could confirm that the announcement or the buzz hadn't happened yet. We were careful about that. I believe all the data that we utilized from the park, I think there were maybe 5 sales, they were all unaware of the park closure.
So you asked them?
Oh, yeah, the
I think the park owner, it's a matter of public record that the park owner intended to close the park, back to 2001 or something like that. I think, the life expectancy of the park was 10 years and so forth.
I am not aware of that, and I don't think the residents largely were from what my conversations and our conversations as my staff were with them. I don't believe people knew about that. At least on the sales that we analyzed, that we included, we had to conduct a very detailed, because they provided a sale to us. We had to interview them for quite a while to confirm it because they're not in the data bank. So we went on and on with lots of questions to make sure that, we were getting accurate information. And by and large, we did. And it was accurate information that was provided, except for one that we didn't get. It didn't come into the data bank until afterward, and it wasn't disclosed to us by the resident at that time.
Okay, I understand. Thank you very much. If the resident's attorney wants to comment, that would be great too.
These people's homes are priceless. You cannot really put.
Ma'am, you need to be called on to speak, please. Thank you.
So, as I stated during our comments, the value of a mobile home has to include the in-place value. And what's being told to you tonight is that the in-place value really shouldn't matter because of the conditions of the park. It's really unfair to residents that the fact that the park owner failed to maintain the park and allow the park to become in bad condition should invalidate any value of the park being in Palo Alto. Our appraisal, the appraisal review that we submitted that looks at the appraisal talks about why in-place value needs to be considered.
Well, Mr. Becker has argued, right, that in-place value, the location of in-place value is considered, right, in the appraisal. That's what he's arguing.
He's arguing that, but he's basically saying that it should be taken into consideration because the condition of the park is so terrible, and that people put up with the condition of the park. And so it's really ignoring in place value, and it's really allowing park owner to take advantage of the fact that they can maintain the park and allow the park to becoming the condition that it is. I mean, it's really not fair to the residents to completely ignore in place value. Mr. Braybrown's report talks about Palo Alto prices increasing by 100% just in the past 3 years. I mean, that the price of housing in Palo Alto has increased exponentially. And just because the park is in bad condition or hasn't been maintained should not ignore the fact that there's a very high value of the park being in Palo Alto. I also just want to remind you that what the ordinance contemplates is not looking at the appraised value, but really looking at what it would take a resident to move to comparable housing, so the comparable mobile home park and a comparable community to Palo Alto. And so that's really the measure that the city council should be looking at.
Thanks very much.
Councilmember Burke?
Well, I'm going to revisit 3 areas that colleagues have already raised some questions on and brought up. We've gotten a good start on this discussion around these, but I don't think we've reached a conclusion on them yet. So let me take the last one first, which has to do with this issue of to what degree has this park been under a shadow of an eventual closure since 2001. And I'm not sure who can best address this. Maybe starting with our city attorney staff. Can you let us know or refresh us on the what was in the public record and public knowledge back from when in 2001 when this last discussion was here? It was in all the papers, and my recollection is as it has been described, which was that it was given approximately 10 years of amortization of its infrastructure. So can we have some light shed on that?
Thank you, Councilmember Byrd. City Attorney Molly Stumpf. So as you know, that predates my tenure with the City of Palo Alto. There certainly are people on the dais and in the room who may have some recollection of those conversations that occurred some 14 years ago. And there's material in the record. It's my understanding from reviewing the material in the record that the primary focus or the instigation of the conversation, the public conversation that happened between the park owner, the residents in the city, involved a rent increase and the city's desire to regulate in that area given the possibility of an increase. And this rent, this mobile home conversion ordinance did result then from those conversations. The parties who have reviewed those records in detail may have additional comments to add.
But that you didn't speak at all to whether there was discussion at that time about this 10-year infrastructure life remaining in anticipation of eventual closure of the park?
So I have not specifically researched that question. There is some material in the record that's relevant to it, and I know that the council has reviewed that as well.
Okay. Can either of the parties speak to this?
In the materials that we asked to be included, the park owner.
If you would announce who you are, that would be helpful.
I apologize.
It's for the record, of course.
I'm Margaret Nando, the attorney for the park owner. In the materials that we asked to be included in the record before you, and indeed what was before also Craig Laverty, was, of course, what prompted the discussion by the council of the mobile home conversion ordinance and the rent ordinance was the notice of a rent increase by the park owner it had been October 1, 2000, effective under the mobile home residency law, January 1, 2001. The council began meeting about the matter in 2000. The ordinance was enacted in 2001. The minutes of those council meetings, which are which were included in the record with Mr. Lavity, for the record before him and included in your packets, reflect that a council member acknowledged that the useful life of the park was 10 years, and that there had been discussion, as I recall it, discussion with the park owner about the life of the park and them continuing its operation. The rent, as I understand the record, the reason a mobile home conversion park ordinance was enacted was because the council and staff saw the end of Buena Vista arriving, because there is no other mobile home park in the city of Palo Alto. The ordinance was enacted specifically with this park in mind. That's my understanding of the facts based upon the record.
So that's consistent with my recollection. So given, let's assume that that is the case, and I think it is, we just heard from the appraiser that, if I understood him right, he wasn't aware of that circumstance.
Oh, sorry. Go ahead.
Yeah. And I guess one question, maybe the appraiser would know this best, is what portion of the residents, current residents, were there back in 2001? Do we know that? Approximately, no?
Okay, Mr. Beckery has indicated he doesn't know the answer to that. I think Mr. Beccaria's point of reference was that in September of 2012, the park owner wrote a letter to the residents saying, we are considering the closure of the park. And of course, in November, an actual application was filed. So I think he was saying, as from his perspective, he did not consider any data after those dates.
And I appreciate that, and that seems completely reasonable. The point I'm pursuing is whether the data for between 2000 and 2012 should reflect the reality that that the useful life of the park was 10 years, and there was an anticipation to some degree by sellers and buyers that what occurred in 2012 would happen in roughly that time frame, whether it's 2010, 12, 14, that notice would occur, that was on the horizon. It was basically 10 years, thereabouts, remaining in the life of the park. So if that's the case, and I'm a buyer, why would I pay the same amount for a residence that maybe only had 5 years of useful life remaining as if I would for a residence if I was going to be able to stay there indefinitely, say in Sunnyvale?
Well, I had this same situation develop in Capitola. It was a little mobile home park that's kind of set behind their city hall in a little valley there. They had a flood a couple of 3 or 4 years ago. It destroyed the park. They had to close the park. The city owned it. They had anticipated it for a parking facility, which now that's what it is. And it was safe that everybody knew it was going to happen, but the sales continued, and you can correlate those sales to the other sales in the marketplace. And the reason for it was that people had very little other alternatives because the prices were just the low end of the market. You know, the mobile home market is it's a place to live, it's basic shelter, you know, and so people were willing to pay for it. As a matter of fact, I remember one instance where I got called into the city meeting to do an appraisal for one lady who actually bought her place and then spent about $50,000 remodeling it. And that was after the notification, and then it went down, and she didn't recover very much of that remodel. That's just how it is with this kind of thing. You're dealing with the very bottom end of the market, and there's a place where the values exchange, and I don't understand any more than what I'm communicating. I know it's Palo Alto. I know you got Stanford, you got all these wonderful things here, terrific schools. That's why it happens. That's why people.
Well, you described that you basically attributed a wash between location and park condition.
Yes.
And I would guess that there are actually maybe three elements in that wash. That the park condition depressed the pricing. The limited remaining life of the park, however vague that might have been, depressed the pricing some. And the location offset both of those. Because that's how we end up getting whatever pricing we have. What I'm going to be leading to is the question of whether the residents, the value of their home should be discounted because the life of the park had a limited future to it, and whether that's an appropriate discount.
Well, the comparables were taken out of other communities for mobile home parks that were traditional that had long-term life expectancies.
Yeah, but if this park had had a long-term life expectancy, how do you know what difference in price these particular trailers would have if there was nothing hanging over the head of this park?
Well, you're making the appraisal assignment hypothetical here then, because you're saying that, assume, Mr. Beckeria, that the infrastructure of the park has been redone. I have to appraise what's there, it's as is. I can't entertain a hypothetical on that issue because you're taking it into something that it's not. It is not a park that has wide streets. For the most part, there's some nicer streets in the back section, but there's a limited number of homes there.
Yeah, in our ordinance, I don't see anything that says, when we talk about equivalent parks, and then we're supposed to discount it, or allowed it to be discounted for the fact that it has a limited life. So we're looking at comparable physical conditions and comparable communities, but we didn't say we should ignore the discounting that's occurring because this park only has a few years remaining on its life, and these units only have a few years remaining.
I disagree with your way of looking at it. I think you're twisting what the facts are into something other than the facts.
Well, before you accuse me of twisting facts, let's just have a discussion. I won't accuse you of twisting facts, and you don't accuse me, okay? Okay.
Well said.
Okay, so please continue.
Not sure what you're asking me now.
Well, I don't know, you're, okay. All right, thank you.
Thank you, Mr. Beckeria. Councilmember Pilson.
Wait, I have two.
I was just thanking Mr. Beckeria not concluding your comments because I wanted the record to show who had been speaking. That's all. I wasn't
Okay,
cutting you.
great, okay.
That's what it was, that's all if you'd like to allow.
I have two more aspects of this I want to pursue.
Okay.
So the other one is on the rent subsidy. And this is what Councilmember Sharp alluded to. It's on page 15 of the hearing officer's final decision report, page 1159 of the full staff there. So, once again, I'm a little uncertain who to direct this to, but because I'm not sure it's really either the ability of either the appellant or the park owner to answer the thinking of the hearing officer. So maybe I'll first turn to our city attorney. We ended up getting from the hearing officer a distinction between how he viewed these additional rooms that were added on and for purposes of appraisal versus how he viewed them for the rental subsidy. And when I do look at our ordinance in page 4, down near the bottom, which is 9.76030, section 5, Roman numeral 5. It actually talks about pop-out rooms. And so it recognizes these. There's an ambiguity, apparently, between whether non-permitted pop-out rooms and porches and all these other things should be recognized as part of the unit, or whether it should not. And for some reason, it seems that the hearing officer said, well, we should recognize them for purposes of the appraisal and not recognize them for purposes of the rent subsidy. So one of my questions for you, City Attorney, is there anything in the ordinance that guides us on why they should be treated one way for appraisal and a different way for rent subsidy?
Thank you, Councilmember Byrd. So you are looking at the RIR informational gathering that is required, and it is required that the park owner describe what's physically present at the park, and that was done in the RIR, and includes those porches, patios, pop-out rooms, etc. And I am reading the hearing officer's decision as you all have as well. The hearing officer, it was independent, and there was no additional consultation that we have done with him, and it would not have been appropriate for us to do that. So we are reading his written explanation. And in essence, he does treat them differently. For the one purpose does then want the appraisal to reflect what's actually present on the site, but then for the rent differential, takes a different approach. And it's my understanding, and the parties, attorneys may be able to clarify, there is a little bit of a complexity in terms of potentially what residents report as bedrooms may reflect additional structures. They also may reflect the way the space within a structure is organized. For example, it may be that a space that was constructed traditionally to be used as a living room has been partitioned in such a way that it's being used as a bedroom. And so some residents are reporting, bedrooms based on additional structures, and some in terms of the way that the unit is being organized internally. And there is nothing specific in the ordinance that dictates how those will be treated for either purpose. So we can read the hearing officer's decision. He chose to handle it in the way that he did, and it's before the council then, for your discretion on both of those items.
Okay. And then finally, this issue of whether the schools are intended to be, I guess the interpretation of the applicant is that they're to be excluded from consideration. So maybe if the applicant's attorney can join us. So is that's your interpretation?
So our interpretation was that when we are talking about the community of Palo Alto, we are, of course, talking about all aspects of the community. However, what the Residents Association was arguing was that the appraisal values should specifically reflect and be increased by the fact that this park was located in Palo Alto and these children would go to Palo Alto schools, and that the comparability of the homes, mobile homes, and other types of housing, condominiums, all should be related to this factor of schools. And we pointed out that you can't, in our view, you could not do that, since there was evidence in the record that other ordinances were looked at by the Assistant City Attorney that included schools, and it was specifically excluded here. And so that has been our argument.
So if I follow that logic, when it says such as, that would have to mean something to the effect of limited to. Those are, to you, I mean, if it's exclusive, if you're saying that the fact that it doesn't list schools means that that was a deliberate exclusion of schools, then what can such as include? If you're saying it's really exclusive when we use this term, such as.
So they're talking about comparable housing that is similar in size, number of bedrooms, and amenities that is being displaced, and is located in a community that has similar access to shopping, medical services, recreational facilities, and transportation, or a comparable mobile home in a comparable mobile home park. Our argument was that shopping, medical services, recreational facilities, and transportation, none of those words is embraced by the school system. That's the specific language in the ordinance. So when you can't stretch that to include schools, then with the definition of comparable mobile home park, okay, that says that, again, there's preliminary language, similar to that in which the park that is being closed is located and has similar access to community amenities such as shopping, medical service, recreational facilities, and transportation. Our view was that, first of all, they failed even after they were modeling this after ordinances which included the language schools, and they did not include it, that the word community amenities, we differ, the Residents Association and myself, on what is a reasonable definition of that word. And when they say a community amenity such as shopping, medical services, recreational facilities, and transportation, the same things that they mention in C, I don't, again, see the definition stretching to include the school system. I did not view it that way. And indeed, again, based on the record that the council discussion and record that was before Mr. Labadie and was before me, when about every time there was a hearing about the enactment of this ordinance and what was discussed. And that's why I was showing yesterday his quote, he did not find the legislative intent. It appears that it was excluded. So that's why I came to that.
Thank you. And does the appellant have any additional response to that?
Yes, thank you. So again, the ordinance specifically says, community similar to that in which the park is being closed is located and has similar access to community amenities such as, that means for example. And if you look at what makes Palo Alto, it's schools. There's not, when you look for housing, and particularly in Palo Alto, they will list which schools are closest to that real estate listing. And that's because Palo Alto, the value of being in Palo Alto, the reason why prices are so high here is because of its schools. And that's a factor that needs to be taken into consideration when looking at comparable housing. So I just want to emphasize that.
So I just share a thought for colleagues that if we were to pursue an avenue that such as is not exclusive of schools, but potentially inclusive, we then run up against the question of, well, how do we value that? We have some inherent value to that education, but we also actually have numbers that are comparable cost to education. Because as we're basic aid district, we title now, but we basically have more expenditure per student than surrounding school districts. And so each student who each year that goes through our district is having that additional dollar amount spent on them. And that's something for us to consider, whether that is an objective way to look at the benefit that's being derived there.
Councilmember Wambach?
Thank you. I also was planning on discussing this issue, and I hate to belabor it, but I'd like to continue to explore the issue that was just raised by Councilmember Burt just a little bit more. And again, I'm looking at not only the comments you just made, but looking at which document is this? This is the pre-hearing statement, page 8, by the applicant, that any mention of the schools within the ordinance is intentionally absent. Again, I find it difficult to reach the conclusion that it was intentionally absent when the language seems open-ended, inclusive, not exclusive. Not only on ordinance page 2, where the words such as are used in describing a comparable mobile home park, but also on page 6 of the ordinance, G, so we're looking at 9.76.040, hearing procedures, which says the hearing officer shall approve the application on the condition that the mitigation measures proposed by the park owner are adequate to mitigate the adverse impacts on the displaced residents, and may condition the approval on additional conditions, including, but not limited to, the following, etc. So there are a couple of places in the ordinance where flexibility and going beyond the examples given are allowed for by the hearing officer. And so, again, the question is, for the applicant, how do you, in light of both of those, how do you justify, first, the claim that we must assume that the absence of the word schools or school district or Palo Alto Unified School District is intentional? And secondly, how do you reach the legal conclusion that we are precluded from considering them, given, again, what I just cited in 9.76.040 item G? So if you could share your thoughts on that, please. The applicant.
So, Margaret Nanda, on behalf of the park owner, the applicant, as you call it. I think that there is two aspects to our position on this with respect to the non-inclusion of the word schools. Okay, so when you look at the definition of comparable housing, okay, it says it has similar access to shopping, medical services, etc. So it does not say comparable mobile home park. The definition does not mirror the language in subsection B of comparable mobile home park, which says such as shopping, medical service, recreational facilities, and transportation. And what we're discussing here and what they're focusing on is comparable housing. There's a difference in the wording. Okay, you're suggesting that the word such as means that the definition stretches. And I was saying that when we were discussing comparable housing, when there is a difference like that in the language between the two, I don't think it stretches when you don't use the word such as. That's number one. Number two, okay, go ahead. Sorry.
No, I'm just keeping track of myself.
So number two, I'm talking about the record of the council minutes and the discussion at the time the ordinance was discussed, and there were several meetings about the council meetings about the language contained in the ordinance. And I am talking about what I pointed out to Mr. Labadie in our closing brief, which is part of your the record before you, that the council meeting minutes and the discussion appear to point to the fact that the Assistant City Attorney, Ariel Colon, was looking at certain ordinances, okay, including the City of Monrovia. It's specifically discussed. The residents are represented by an attorney, Bruce Stanton, who is a well-known attorney practicing about the same amount of time that I have, who normally represents residents. He is representing the group of residents, and he represents to the council that he has reviewed over 150 ordinances, or something to that effect, and that the language here is exactly what it should be. Okay, so that's the first thing. And again, then, now you're saying that now you want me to turn to a different subsection where it talks about.
I'm not saying, I'm merely asking.
Okay, yes, okay. So you're asking me to look at section 040 and subsection G.
Yes.
That, because he can condition additional conditions, including but not limited to the following. And so, yes, if you're asking me, does that language provide for a plethora of possible additional conditions? Yes, that does not necessarily mean that they are related to or justified by the terms of the ordinance. Furthermore, I think that the fact that that language is there, Councilman Woolbach, and that Craig Labadie in his decision specifically resists and rejects their suggestion that schools should be included because he finds a lack of legislative intent on behalf of this city council dictates that that should not be stretched to that. Because if he's finding that there is no basis for it, why would he stretch to that? If you're asking me, is it possible for him to stretch to that? Of course it's possible, but he did not in fact do that.
So does he exclude? So,
for the reasons that he states there.
okay, so let me see if I can respond or have follow-up questions for each of your responses there. And I appreciate your responses. Thank you very much for engaging with these very complex topics. First, you identified that in 9.76.020 definitions, although the words such as, which I think we can agree now are inclusive and not exclusive, appear in subsection B, the inclusive and broader language of such as is not included in subsection C. However, subsection C, does it not refer back to subsection B when it refers to a comparable mobile home or comparable mobile home park at the end of that paragraph, thus leading us back again to the inclusive language? Thus, subsection C includes subsection B and thus includes the broader language of such as. Does it not, or am I misinterpreting this?
I'm not saying you're misinterpreting it. I'm saying what I've been saying all along. You are stretching, you are saying such as basically the lead-in to an unlimited field. And I'm telling you, in my opinion and experience, it is not. And that such as those words that follow it don't stretch to schools. And I've said that all along. And then in the subsection C, it's similar access to the specific things that they mention there, or yes, comparable mobile home. We disagree on the meaning of such as. And so I understand your position that it stretches to include everything. I just don't personally agree with that.
Okay, well, I'm not sure that it stretches to include anything and everything. Again, you know, my question here is, one, does the reference of subsection C back to subsection B mean that we can see some flexibility? If, however broadly you define such as, there is certainly more broad language there that is certainly more inclusive and broad, open-ended statement than its absence. That's why you've drawn the distinction between subsection B and subsection C, because such as is more inclusive and not as exclusive. So we agree that such as is somewhat more inclusive. We have yet to determine exactly how much more inclusive it is. But does not the reference of C back to B by using the phrase comparable mobile home park, which takes us back to the prior definition, does that not mean that subsection C also includes that flexibility, however broad that flexibility is, of such as?
It is, if you can interpret it that way, although it is very interesting that the items are not expanded. It is such as, those are the same, right? Shopping, medical service, recreational facilities, and transportation. So again, in my view, since those don't stretch to school, the fact that it refers back to that definition is not, does not mean that all of a sudden schools are included in comparable housing. I know we see it differently, but that's what I'm saying.
Well, again, I'm just trying to break this down one step at a time.
Okay.
And you might be right, I may agree with you in the end. Again, the specific question we're focusing on is whether C refers back to B, and it seems that you agree that it does.
Well, to the extent that it talks about a comparable mobile home to a comparable mobile home and a comparable mobile home park, and there is a definition of that in the ordinance, in A and B. Yes.
Okay, thank you. So we agree on that.
Okay,
Again,
all right.
it is certainly clear that the word school, the phrase Palo Alto Unified School District or school district, or the value of local education, none of that is included in the ordinance explicitly. Completely agree on that. However, so the next question is, I'm not sure how the failure of the city attorney at the time of the writing of the ordinance to include one additional specific example of a community amenity is evidence that it was intentionally excluded when inclusive language was listed. The point of inclusive language is to say that it could be other things that we've left off from this list. Think about Amendment 9 of the Constitution, where it says, essentially we've listed some rights of individuals, and we might have forgotten some others. This should not be read to be an exclusive list. That's the point of adding expansive language, right? Is to prevent anyone at a later time of saying legally this is an exclusive list. It's to leave an opening for at least consideration of other items which may have been left off. Is that not the point of more expansive language in general?
Well, of course, attorneys often use the phrase including but not limited to. We don't really use the phrase such as. I think the point here again, and I can only make it one more time, maybe I'm not being clear, I would again refer you to the record below. You look at a lot of, or I have looked at a lot of mobile home park conversion ordinances. City of Sunnyvale, for example, includes the word school. Okay, San Jose includes the word schools in this definition of comparable. Now we have an assistant city attorney and the attorney for the resident association. The assistant city attorney drafts the ordinance. He drafts the ordinance at the instruction of the council. And he says, I looked at and compared this, and he mentions the city of Monrovia. And again, I don't think that my conclusion is so far-fetched when, again, the hearing officer, who I had no control over.
And I've not claimed you did.
When he came to the same conclusion I did, was that for the Residents Association to contend that schools are included in the definition when the legislative record, when the record below does not support that he found a lack of legislative intent to include schools in the definition.
Right, so there was clearly an absence of those words in the legislation. We can certainly blame the city attorney at the time, or assistant city attorney, and perhaps even the council at the time for not including that explicitly. However, again, the point of including expansive language, even if it's not the more typical legalistic language of including but not limited to, the purpose of including expansive language, unless I'm mistaken, it seems you agree, is to allow for consideration at a future time of items which may have not been included in a specific list.
The reason I don't necessarily agree with you, council member, is because, again, the schools were apparently, according to public testimony and the hearing, and for those residents who had lived in the park a long time, just as important and just as much a factor in the city of Palo Alto in the year 2000 and 2001 as they are today.
Right, again, I
And
understand. So I actually graduated myself from back in '99, so I'm aware of the high quality of our schools prior to the writing of the ordinance. But again.
So my assumption is that it's that important, and if it's in other ordinances that the city attorney is looking at, they would have included it.
So again, I recognize that there was a failure to include it specifically. The question is how you reach the conclusion that its absence was intentional when there was, and secondly, let me get back to the larger point, which is even if it's not there, what precludes us from consideration of this in some way at this point legally? Is there some legal prohibition on us considering this? And this is something that's open to the city attorney, but since you're already standing, I'll give the applicant's attorney a chance to speak. Then I'd like to hear from city attorney, and then also turn my line of questioning to the appellant.
So I would.
But thank you for bearing with me through a difficult point.
No problem. I think again, its absence and its intentional absence, in my opinion, based on the record of the council means that it should not be included in a later date. Because it's not up to this council now to interpret well, you can look at the ordinance. Ordinance is the law in the city. It was adopted in 2001. It says what it says. And it's not up to us to rewrite it. And as I understand it, that it is unusual in administrative practice and interpretation of ordinances to read into them more than what is contained in them.
I understand what you're saying. I disagree to the extent that I think that the inclusive language allows for at least consideration of some things which might not be explicit. Although I have yet to determine for myself, and I think my colleagues may agree, whether that would include the schools. However, again, the question is whether it specifically excludes the schools. And secondly, is there legal prohibition on us considering that in some way? Again, referring back to 9.76.040 subsection B.
So since I think I've said all I can, I guess your question is.
I'll turn to the city attorney.
Thank you, Councilmember. This is an issue that was contested between parties. It may remain a topic of additional legal procedure. It's before the council for determination. It's not helpful to the city for me to comment publicly in this forum.
Thank you. And also, I'll turn to the appellant's attorney. So you've heard the discussion we've just been having. So for the residents' attorney, you've obviously placed a great deal of emphasis on the schools, on the importance of the schools. There's obviously a debate about whether they even can be considered. But I'm curious to hear, after all the time you've spent talking about the schools, to what end, legally, in this procedure, recognizing Palo Alto schools are fantastic, those of us who attended them, or friends and family and neighbors who attended them, but in the context of this proceeding, exactly how do you propose that the relocation package be modified, improved, to accurately reflect what you see and demonstrate would reflect the presence of Buena Vista within the Palo Alto Unified School District. And I'm looking for specific asks that relate to action that we can legally consider in this procedure.
Well, thank you. I think you hit the nail on the head when it comes to the issues about schools. If an ordinance is clear about what amenities required, your intent really shouldn't be considered. And the ordinance specifically talks about community amenities, and like we stated, this such as allows for an exclusive list of amenities which should include schools. In terms of how schools play into your decision and what you look at. We've talked a lot about the plan that the park owner needs to come up with. And so,
although that's debatable. but not really my line of questioning. Sorry to interrupt.
So when you're looking at the relocation assistance that the park owner has to provide and what it's going to allow residents to move to a comparable community, you should require this park owner to include schools in that list of comparable communities and assess what comparable communities are that residents can move to that have comparable schools, and then will allow residents to have a high quality education similar to what is available to students in Palo Alto. When you look for housing, there's a list of amenities that are included with that housing. In many, many cases, the first thing that comes up is schools. It's the most important community amenity, especially for families with children, which make up the vast majority of Buena Vista residents. And so what we request that the City Council do is instruct the park owner to require a relocation assistance that's not only going to allow residents to move to comparable housing, but is going to specifically include schools in that definition of comparable housing.
Thank you.
Okay, I just have a couple of 3 questions. I'm confused about something that was said earlier and is in the record. And I guess first I will ask the owner's attorney. Lavity, when he looked at the existing living units there, said that he gave the owners credit for 2 to 3 bedrooms, and that was appropriate, but not in considering relocation. And so it's confusing to me, like how you can get credit on the one hand, but not have that carry through when considering relocation. So,
Well, okay, so Margaret Nahman on behalf of the park owner. So, Mayor, I think the 2 to 3 bedrooms or bedrooms that they created in these homes, often by drawing a partition across a room or so on and so forth, those were recognized as bedrooms in the appraisal. And so the appraised value reflects the illegal or additional bedrooms that people created. Now what he didn't, so it is recognized and compensated for. What he didn't do was say that when a park owner, when a mobile home or trailer owner or RV owner at Buena Vista created out of the living room by drawing a string across the room and erecting a curtain, a bedroom, that when we pay rental subsidy, that we must pay we must count the number of bedrooms that were created by the tenant at Buena Vista. So it was included in the appraised value of the home, which is part of the relocation assistance because it's included in the lump sum package.
it still seems lopsided to me. And I guess this might be a question for city attorney. We don't have any zoning that I'm aware of or could find that governs mobile home park, additions, setbacks, anything of that nature. I did not find anything of that nature.
Thank you, Mayor Holman. So I'm not a planner, but it's my understanding that those issues are regulated by the state, by HCD, which typically delegates inspection authority to the county. So although the park resides within the city limits, this type of activity is undertaken by the county.
So what triggers legal nonconforming? So the value is considered in terms of appraisal, but not in terms of moving forward. It goes to what Councilmember Sharp was talking about a 1-bedroom versus a 2-bedroom. So, what constitutes legal nonconforming? So even if it was like, a tough shed set up against the trailer, would that be considered legal nonconforming and should be counted?
So again, Councilmember, again, I'm not a planner, but it's my understanding that these units would not be permitted, or construction work on the units would not be permitted in the same way that the experience that you're drawing on, which is traditional housing in all the other residential zones within the city. So we don't have that same type of situation. These issues are regulated by state law, and then again, HCD is working with counties on some implementation issues.
It seems similar to me. I think I just have, maybe one more comment. There's been a lot of discussion about, schools being included or not in the language such as, and statements made that it's not explicitly included, so it wasn't intended to be there. And the word intention and intent has been used a lot. I'm not an attorney, you're not a planner, I'm not an attorney, but in 5+ years on council and 8.5 years on planning commission, I've been instructed and corrected by a number of city attorneys. I remember in one particular case, in looking at the zoning ordinance update, that the then city attorney, when we were looking at what language we wanted to use to give clear direction on something, we were struggling with language, and the city attorney then said, I can't interpret intention. And I guess this is more of a statement than a question, but the word intention and intent has been thrown around. I understand the arguments, I hear what your basis is, but that's always stuck with me. I can't interpret intention. So maybe city attorney has something to say with that.
I think I actually maybe can make some general comments about this. The reason that the parties have referred to that, and that the hearing officer, I believe, uses that word in his decision, is that we are all lawyers, and when a court looks at a writing, a contract, or a statute, or an ordinance, the court asks what was intended by the language. So that's a traditional activity that we engage in as lawyers. It's not the same thing as looking into someone's heart and mind. It's not personal in that regard. It's an attempt to ascertain what was meant by the language when it was drafted.
And that also seems very close to me. So I think this would be a really good time to take like a 5 or 6 minute break, stretch our legs. Councilmember Sharp?
Just before you do, if you can just indulge me, I had one follow-up to Corey's such as question for Ms. Nanda. So I wanted to make sure we were on the same page in terms of how the ordinance works. So the term comparable mobile home park has different language than comparable housing.
That's correct.
If you want to just pull it up 3, it might be easier for you. It's on packet page 3 or 2 of the ordinance definition we have. Right. So I'm looking at comparable mobile home park and comparable housing. Comparable housing does not have the such as language. Comparable mobile home park does. Right. The only time in the ordinance that comparable mobile home park matters is when you're going ahead and taking your existing mobile home park at Buena Vista and physically moving that mobile home park. Otherwise, the language does not matter. Is that correct?
That is the only place. In addition, I think it's important to recognize that, again, there are no other mobile home parks in Palo Alto.
No, wait, that's irrelevant. I don't see what you're saying. The point is, I'm asking you, when you were asked about the such as questions, that would only apply if someone was moving their mobile home park from Buena Vista to another mobile home park. If you're looking at the opposite of that, which is a lump sum payment, then we're talking about comparable housing. And comparable housing does not have the such as language.
Yes, in the, so you're talking about 9.76040 hearing procedures, where it talks about in subsection G, what I was talking about with Councilmember Wolbach, which is including but not limited to, and it divides it between residents whose in subsection 1, residents whose mobile homes can be relocated to a space in a comparable mobile home park, and then says what benefits what mitigation assistance they will receive. That is correct.
And they're two different ones, so I guess my question was, it seems to me, actually, and this wasn't addressed by the hearing officer, that the only time the schools may actually get in there, according, under Councilmember Walbach's argument, and they might actually, would be if someone was actually physically moving their mobile home park. So is anyone physically moving their mobile home park? Because if so, maybe we should take the schools into consideration on that. But if they're not physically moving their mobile home park, I don't see the argument for taking the schools into consideration.
So, again, we discussed this in the RIR, and then we discussed it at the public hearing. The age of the units in the park, with the exception of the park, there's something called a park unit, which Mr. Beccaria referred to, which are not mobile homes and which are registered through the DMV, but which are the most recent, are the least old in the park. It's possible, but in my view, highly unlikely or improbable that they could be moved. I say that because no park will accept them.
So there are different benefits. So at some point, do the residents then choose and say, I'm moving my mobile home park because I found this park that will take me? Or do they must choose at some point?
Yes, they
There's
do,
different
they
benefits.
do, again, with the assistance of the housing relocation specialist. First of all, any vacant mobile home spaces in any parks are available. And again, what is available today is a snapshot. What is available when they move is another matter. Then, of course, there is the issue of whether or not, even with a vacant space, the mobile home, RV, trailer, or whatever would be accepted at the mobile home park. And that, I can only say, again, in 35 years of experience, is that my experience is that either brand new homes are accepted, purchased through dealers, or very new homes. Because park owners accepting new homes into their parks, or accepting different homes on a vacant space, want to improve the overall appearance of their parks. It isn't a situation here where park owners are sitting around with a lot of vacant spaces.
Okay.
Okay, so.
I got that. Thanks.
May I respond?
Yeah. Oh, absolutely.
Thank you.
With all due respect, I do want to point out that the definition of comparable mobile home park, which refers to the specific amenities, does come into play for residents whose mobile home cannot be moved. The ordinance specifically says a lump sum based on consideration of the cost of moving to and purchasing. I'm sorry? Oh, I'm sorry. This is 9.76040 F2.
Page 7 of the ordinance.
Page 7 of the ordinance.
So page 7 of the ordinance.
Yes.
Two.
Okay, yes, this is section 9.76040. It's a lot of letters, I'm sorry.
Right. You're in receipt.
FA2. And this is for residents whose mobile homes cannot be moved. It's a lump sum based on consideration of the cost of moving to and purchasing or renting comparable housing, including but not limited to the cost of purchasing a comparable mobile home in a comparable mobile home park. And if you turn back to the definitions of both a comparable mobile home and a comparable mobile home park, that's where the question about the list of amenities and the term such as that we've been talking about. I also want to point out that the term comparable housing specifically references page 2, subsection B of section 9.76020, the definitions. And let me read that to you. It specifically says, located in a community that has similar access to shopping, medical services, recreational facilities, and transportation for a comparable mobile home in a comparable mobile home park, which references to the earlier subsection B, which talks about comparable mobile homes, lists the community amenities such as that we've been discussing. And the reason this is important is because schools come into play for both residents who can be moved, whose mobile home can be moved, and those residents who cannot be moved. I also want to make a point about going back to page 7, subsection F2A. That section is expansive, and it's your role today to interpret your ordinance as you see appropriate. And the ordinance allows you to have a de novo review. So you don't have to take everything that the hearing officer says. And if you think that there are certain things that are important that need to be part of the mitigation assistance, it is not just the option, but actually your responsibility to include that as part of the mitigation assistance that residents receive. The lens that we have to look at this through is what is it going to take to mitigate the negative impacts of the park closure. And if schools need to be considered, and if there's some kind of payment that the residents should receive for losing the opportunity to attend Palo Alto schools, that needs to be considered as part of the mitigation assistance. This is about mitigating the negative impacts of the park closure and allowing residents to move to a comparable community as Palo Alto. We've stressed this so much tonight, but that needs to include the schools.
Thank you.
Thank you. Then we have two very brief follow-up here. One Councilmember Wilbach, one Councilmember Berman.
Really quickly, actually, I think that I actually agree with this point of the appellant's attorney that essentially the definition of comparable housing includes the option of a comparable mobile home park. And we see that on page 2 of the ordinance, and we see it on page 7 of the ordinance, at least, and there might have been a third place as well. Oh yeah, and also on page 5 of the ordinance as well, under I, right in the middle.
Councilmember Berman.
It sounded more like a statement than a question. So let me ask a question of the appellant's attorney, if I may, and then I might bring it to the applicant also. But so in regards to the issue of schools, and I'm not trying to imply one way or another what my thoughts are on it at this time, but I am trying to think of functionally how that might be addressed in the relocation package. Is it the intent, and I am looking for specifics here, is it the intent of the appellant that be factored in on the part of the rent subsidies that are provided, or is that factored in terms of the appraisal of the mobile home?
That's a good question. Like we said, it's how you interpret it, and I think that the schools can be factored into both the definition of comparable housing, because we're talking about the vast majority of residents who can't stay in Buena Vista, and so it contemplates moving to a comparable community, comparable mobile home park, all of those community amenities such as schools. The rent, it's realistic or it's a good possibility that a lot of residents are not going to be able to move to a mobile home, a comparable mobile home, and their options are going to be to rent. And so in looking at rental opportunities as a source of comparable housing, I think that the council should also consider schools and ability to access similar quality schools that Palo Alto has. I mean, you've heard a lot of testimony about that. You've heard the vast difference in dropout rates for Latinos living in Buena Vista versus living in the Silicon Valley generally. And so this is a very, very important issue.
Thank you. And now a quick question. No, that's it. Thanks.
Okay, council members, let's take a 6-minute break, and I ask that everyone come back, please, in 6 minutes. Thank you.